Hello everyone, this is the video of Legal Studies Class 12 Unit 3, namely Arbitration, Tribunal Adjudication and Alternative Dispute Resolution. And from last a few videos, I have been discussing different subtopics given under the Arbitration, Tribunal Adjudication and Alternative Dispute Resolution. So, by the time we have discussed about the arbitration and other concepts. So, in today's video, I will be discussing about the administrative tribunals. So, first of all, what is meaning of administrative tribunals? Administrative, as the term suggests, that it is something that administers, or in other words, the meaning of administration is that it manages the public affairs. So you can say that it is a group of individuals who are in charge of creating and enforcing rules and regulations, or those in leadership positions who complete important tasks. So what it does, it manages the duties, responsibilities or rules, everything. So that is meaning of administrations. Now check out the meaning of tribunals. The meaning of tribunal is a body established to settle certain types of dispute. Okay, so you can say that it is a quasi-judicial body that resolves the dispute. Now we have two terms and we have seen the meaning of these two terms, administrative tribunals. Now if you club both these two terms, if it is administrative body who does the adjudicatory kind of work, and in other words you can say that resolving the dispute, then it is known as administrative tribunals. Okay, so now check out the collective meaning of these two terms. So administrative tribunals are specialized government agencies established under federal or provincial legislation to implement legislative policy. Some public boards and public decision makers or also have had powers of decision making conferred upon them by a state. So administrative tribunal is a body that practices the power to adjudicate. So this body makes decisions if there is in reference to the disputes between two parties, especially when there is one government department party and the other party is a private person. So this is the meaning of administrative tribunals. Now you might have the question that how it evolved. So let's check out the historical aspect. Though it is not so old, in 1976 through 42nd Amendment Act, the Parliament added Article 323A and 323B to the Constitution of India. Under these two provisions, the Parliament now can set up tribunals for adjudication of specialized disputes. Some of such specialized disputes are disputes pertaining to service conditions of the government officers. So if you are in government service, especially in central government service, and if you have the dispute, then your dispute can be resolved through such tribunals. Collection and enforcement of tax. So if you have dispute regarding the tax, then you can also get resolved through such tribunal. Industrial and labor disputes, matters concerning land reforms, elections disputes, sealing on urban property, and production, procurement, supply and distribution of foodstuffs or other essential goods. So if you have the dispute regarding any of these things, then you can get it resolved through administrative tribunals. Okay. In addition to this, after the 42nd Amendment Act, the era of tribunalization of Indian judiciary officially commenced. Okay. So you will find there are number of tribunals being set up for a specialized subject matter. So the enactment of Administrative Tribunals Act 1985 took the constitutional objective further and set up the Central Administrative Tribunal, in short CAT, and state administrative tribunals. CAT exercises jurisdiction of service matters of employees of central government, okay, and SAT, that is SAT, State Administrative Tribunals. It looks after the disputes related to the employees and the state government, because he is the employee of a state government, okay, and CAT is regarding the central government, okay. The appeals against the orders of the administrative tribunals lie before the division bench of the concerned high court. If you are the employee of Maharashtra government and if you have dispute regarding your employment, then you will file the case where? In the State Administrative Tribunal. If your dispute is being resolved satisfactorily, no issue, you accept that. But if you are not satisfied with the decision given by Maharashtra State Administrative Tribunals, then you can file the case, or you can appeal, in fact, in the Bombay High Court, because it is the matter of Maharashtra state. So you can file in the Bombay High Court, and so on and so forth. So if you have the dispute in Kerala, then you can file in the Kerala High Court or accordingly, okay. Moreover, the tribunals are procedurally flexible, and this flexibility increases their efficiency. For example, the Administrative Tribunals Act 1985 allows the aggrieved persons to appear directly before the respective tribunal. The overall objectives of the tribunals are to provide a speedy and inexpensive justice to the litigants. So here you can get the fast justice or a speedy justice, and you don't need to pay much amount to get the justice, okay, as the procedural cost in comparison to litigation is much less, okay. So this is all about the administrative tribunals, okay. In next video I will discuss about the mediation, so keep watching.